Hey, welcome in, everyone. Welcome in. Welcome to my channel. I am the Educated Natural, and I am super excited to be back with you all. I know it has been a while. I know my apologies, but life be lifing, and I have recently underwent a move. My family and I from one state to another state, and so if you've ever moved, you can understand the stresses that go along with that and all the changes associated with it. So we have been through it, but we thank God we have made it to the other side of the mountain. My family and I are comfortably in our new place here, and we thank God for it. But when I tell y'all my testimony in a later video about this move, ooh, child, y'all gonna celebrate with me. But thank you all for being here today at the Educated Natural channel. I understand you could have been anywhere in the entire world, anywhere on the internet, anywhere on social media, but you took time out of your day to be here with me, and I am honored. And I thank you. If you are new here, let it be known, tell everybody that while you are here on the Educated Natural channel, I make you a vow, and that vow is I will never leave you uneducated. Can't do it. It's just not in me. I can almost guarantee you while you are here, you are bound to learn something that you did not know prior to your arrival here. So get your pens, get your paper, get you something to drink, get you a snack if you need to, because we have a lot to go over today. As you can tell by the title of this video, we're going to be looking briefly at the USPTO's proposed fee increases. Now, this is dealing with patents and trademarks. But of course, you know, here I shine my attention a lot on trademarks because that's something that I have, that's something that I know a lot about. And I know a lot of you are interested in filing your own trademark. So we're going to keep today's discussion primarily on the trademark proposed fees that the USPTO is proposing. So let me tell you something. If you think it's too high now, baby, you haven't seen anything yet. I'm telling you, when I ran across this information, it was during my move, so I couldn't tell you all right then and there. I was moving. But now that I'm settled, we have a lot of talking to do. So before I get into today's discussion, let me take a moment to welcome those of you who have said hello to me in the chat. I would like to be respectful and say hello back to each and every one of you that I'm able to see. Hello and welcome into Passionately Intrigued Arts, Official Jamia, The Experience with Sassy, Crafty Leo, Yaya's Best Life. Who else we have here? Tamika Davis. Going down, let's see. The Experience with Sassy. Jared Talks. Thank you all for being here. And as everyone else is coming in, I see the numbers are going up. So slide over, everybody. Get real comfy because they're coming in, because everybody wants to know what in the whole world is going on. What are you talking about, the Educated Natural? A fee increase? Hold on a minute. I'm already paying a pretty penny for these trademarks and patents and everything else that I have going on in my business. What do you mean they're about to increase the prices? I told y'all it was coming. I tried to warn my fellow entrepreneurs out there. I've been talking about this for almost 2 years. I've been telling y'all, put your money aside, protect your intellectual property. Now, some of y'all listened, some of y'all didn't. And I'm telling you now, if the USPTO has its way, we're about to be reaching deep in our pockets to protect our intellectual property. They are no longer playing games. They have had enough of bad applications. They have had enough of the people overseas filing applications that's not right. They have had enough of the foolishness at the USPTO.gov website and all the trademark and patent attorneys there. They have had enough, y'all. And now they're going to say, you know what? Y'all are going to have to feel this pain that we've been feeling by reaching deep into your purses and wallets and pocketbooks and bags or wherever you keep your money at, your bank account, because you're about to pay, baby. You about to pay. So if you think attorney fees are high right now, you haven't seen anything yet. If these proposed fees are implemented, attorneys' fees are going to go up too, because you think they're going to take that hit? No, It's going to come from the applicants that want to file trademarks. All right. So I'm telling you now, heed my warning. If you're thinking about filing a trademark, do your research now. And when I say now, I mean as soon as this video is over with. Do your research. Get with your trademark attorney. Reach out to me, and you need to start the process of filing your trademark before these rate increases come into effect. I'm going to show you what they're proposing in just a minute, but I need y'all to understand, if you're thinking about it, if you're building a serious brand, trust me when I tell you this is not something you want to no longer procrastinate on. These fees and the things they are talking about implementing are going to hurt. You may feel it financially. So, heed my warning. If you know you're building a brand, if you know you have a slogan that you are known by, and it would upset you if someone else in the marketplace is using said slogan, said business name, said colors and sounds, or whatever it is you're building and you're attaching to your business and your brand, whatever it is you're building, whatever product, whatever service. If you want to protect it and truly own it, you're going to have to get on the ball now and file your trademark prior to these prices coming into effect. I can't stress that to you enough. Now, if you're just a hobbyist, you're just playing around with your brand, you're just playing around with your business, this probably don't apply to you because you don't plan on protecting nothing anyway. Do what you do. But if you're a serious business owner, you can no longer keep procrastinating on protecting your intellectual property, whether it's an invention, whether it's something that can be trademarked, even if it's probably something that you need to go through the USPTO to get copyrighted. If you have to do something on a federal protection level, you better do it now. I'm going to show you the words directly from the USPTO. Anyone else that I may have missed before we get into this, because time is of the essence. I don't want to make this too long, but I want to make sure I give you the information while it's hot off the presses, while you still have a few more months to get yourself together. All right. So let me start back. Where did I leave off at? Let's see here. I'm going up. 755 Media. Thank you for being here. Deborah Garrett, great to see you. Thank you for being here. Crafty Leo, thank you for being here. Let's see. Going. I want to leave nobody unspoken to. Precious Pieces, thank you for being here. All right, if I missed you, just say hey again. I'll catch you in the next round, all right? So thank y'all for being here. So let's get right into it. I'm going to share with you, which is public knowledge, all right? You can find this on the internet over at the USPTO site yourself, because I'm not going to go through all of this because it's long. It's very long, a lot of information. And we'll have time for all that, all right? I'm going to share with you the slides that the USPTO.gov recently released to the public when they gave public people like you and I back in May of this year a chance to come and for them to tell you about the proposed fees and for you to have the opportunity, if you were selected, to go and stand before the board and tell them your grievances with what they were proposing. Some attorneys and some other people took advantage of this. Some people weren't notified in time of it. For whatever reason, it was a whole mess, but those that were able to make it were there and gave their opinions on this. But what I'm going to share with you today is the actual slideshow showing the reasoning behind these fee increases. Now, like I told you earlier, I'm only going to show you some of the ones that deal with trademarks. All right. Now, this is a very long slide presentation. We're not going through all of it. I just want to show you the main things. It's probably going to make your eyebrows raise. Okay. So let's get into this. Give me a second. I'm going to share my screen here. Now, a lot of people, thank you so much, Sassy. Thank you. Thank you. Many blessings to you, sis. All right, let's get this on the screen. Come on over. Come on. Where'd it go? All righty, daddy. There it is. I'm like, what's taking so long? I tell you, boy, people be these companies, other companies and stuff just don't work right. It's crazy. All right. I think we're good. Okay. So here are the slides from the USPTO. Now, a lot of people were questioning why now are they raising rates? And according to these slides that they have released, these are their objectives and the reasonings behind their proposal. They're saying basically in this slide that because of their aggregate costs to be able to do the things that they do at the USPTO, that's one of the main reasons as to why they're proposing to raise their rates. Because so many people have decided to file trademarks from 2020 until now, they have received an influx, like hundreds of thousands, probably, I know definitely thousands, of trademark applications coming in. The USPTO only has so many attorneys to be able to handle this influx of applications. So it has made them suffer through the burden of having to go through each and every one of these applications. So they're saying, look, this has increased the financial needs and strain on us. So basically, I guess you could say the demand, which is all the applications that have come in, they just are struggling to keep up with demand. So I guess it's almost like a demand and supply type thing. So because it's costing the USPTO more money, where do you think that extra money is going to come from? They're not going to cut their pockets. They're going to take it out of the applicants' pockets. Because by and large, we are the ones that's filing trademarks, that's putting more things on their desk, right? So they're saying here, these are their objectives. They want to recover aggregate costs. They want to enable financial stability. They want to better align fees and costs of provided services. They want to improve their processing efficiencies. They want to enhance the quality of incoming applications, and they want to offer affordable processing options to their stakeholders. Who on this list don't you see? You. So they're not really concerned about how much money you're making in your small business or large business. They're only concerned with what impacts the USPTO. All right. So I wanted to show you that. Let's keep going. So in this slide, you can see where they're talking about resource and mission benefits for intellectual property IP stakeholders. It's all about those stakeholders, right? They have to make sure they're doing what they require as well. So I'm not going to go through each one of these bullet points. You can see them there on your screen. Feel free to pause this later in the replay, read through it yourself, because we got to get down to the meat and potatoes of, us. So let's keep going. So now, the financial outlook, according to the USPTO, the trademark fee schedule generates aggregate revenue to recover aggregate costs. What's happening is aggregate revenue is not recovering that aggregate cost under the existing fee schedule for two principal reasons, according to the USPTO. Trademark demand and applicant filing behavior has changed, meaning trademark demand surged, meaning it went up, without a commensurate surge in maintenance and intent to use filings, then softened relatively to prior forecasts. Basically, in 2020, it surged up. Y'all all know what happened in 2020. Everybody started a small business. Everybody thought for sure that I'm going to be a business owner. So everybody started protecting their IP, and the application numbers soared a lot. So now what's happening in 2023, they hit a dip. So it was going like this. And I believe there's a slide in here that may show that. If I can get to it, I'll show it to you. But in 2020, 2021, it was like this. It was going up. Well, 2023, it started to dip down. So it's going down. but they're predicting it to shoot back up again. Okay, so that's what has happened. Things have taken a turn, and the cost, and y'all know they got the other thing on here too, inflation. You could go to your local grocery store and see inflation, child. So the USPTO is saying, hey, look, a broader economy, we've experienced higher inflations, and the aggregate costs have increased. And so things are just off with these current fee schedules. So in order for us to kind of try to balance things out again, we're going to have to raise our rates. So that's what they're looking at. Inflation, as well as their aggregate costs. Something's got to give. All right, so let's keep going. Now, here is where we get into this fee thing. Everybody, y'all good? Everybody good? Welcome in, Barb. Thank you for being here. I want to make, because when y'all see these, because when I saw them, I don't even have pearls, but I was like, oh, I couldn't believe it. I really could not believe this. So let's get into this thing. All right. Here is what they're proposing to change. Based on their review, they want to make adjustments to the following fees: applications, intent to use filings to include amendments to alleged uses, statements of use, extensions for filing a statement of use, letters of protest, maintenance filings to include renewals, declarations of use, declarations of incontestability, petitions to the director, and petitions to revive an application. Now, for those of you that become a part of my membership that I will be releasing this week, if you need me to go deeper into what all these things are, I will. But usually my students have access and know about all of these things. And for the sake of time, I won't go through every single thing. But if you want to know more, you got to be a part of the fam here. So if you haven't become part of the fam, by hitting that subscribe button, you might want to do that. And when I open up memberships, you definitely want to be a part of that, because I break all these types of things down for you. Because I told you, I will never leave you uneducated. But for the sake of time, we're going to keep going. So now, here's what the applications part of this is. And that's the thing that we all fill out when we apply for our trademarks, patents, so on and so forth, right? Trademarks. So they're saying, propose implementing a single basic application filing option with a corresponding fee and discontinuing the current trademark electronic application system, which we call TIS, standard, and plus application filing options and fees. Now, if you've been here long enough, you know I've told you there are two applications you can file right now at the USPTO to file your trademark. One is for TAS standard. The other one is for TAS plus, right? They have two different fees associated with each one of those. The current fees for them right now is $250 and $350 currently, all right? They're saying on this slide that they want to just get rid of both of those, discontinue them, in order to implement a new type of application. All right. So this is basically what this is saying. Hold on. We're going to get into the rest of this. But they're proposing here to get rid of what they already have in place. And they're going to implement a new application process. So let's keep moving. So like I said, they're proposing a new single basic application. No more two applications, just one application. All right. They're calling it a premium application. And it has a surcharge fees based on the following actions an applicant can take during the filing. Okay. Submissions of incomplete applications, other than applications denied a filing date for failure to satisfy the requirements under 37 CFR 2.21. All right, so all that legal stuff. Custom descriptions of goods and services in the free-form field instead of using the pre-approved drop-down fields containing the acceptable identifications of goods and services from the trademark next generation ID manual. The ID manual is what, when people file their trademarks, is where you get the descriptions in the trademark per whatever it is you're trying to trademark. So when you look at a person's trademark application or their certificate, you will see all these things that says their trademark. That's all the things they're protecting. They get that from the ID manual. Or when now that we have the other application, which is the more expensive one, your lawyer or your attorney, or you can go in there and kind of freeform it yourself. Well, they're trying to say, yeah, no, no. It's going to be completely different now. So you can read through that, give you all the information about the form changes. Let's get on down in this thing. Uh-oh, too far. Now, here is where we get into the fee changes. Hope y'all are still with me. Y'all still with me? Let me know. Let me see a one in the chat if you're still with me. Let me see. I want to make sure I don't want to lose nobody, because now things are going to get spun up a little bit. So I want to make sure y'all are still with me. Because from this slide on, y'all are going to see the difference in the fees. Thank you, 755 Media. Y'all about to see the difference in the fees. All right. Propose setting the fee of basic applications at a rate greater than the TEAS plus fee to recover some additional examination costs earlier in the trademark life cycle. They want to maintain a subsidized, low-cost filing option for under-resourced and underrepresented brand owners. Not all costs are recovered. So this is their way of saying, hey, we're still going to kind of keep it on the low end because we're thinking about y'all. But y'all look at these prices and tell me, really, do you think they're really thinking about you? Okay. Hey, Tay, welcome in. So right now, you can file your trademark through paper, or you can file your trademark through electronic means. Now, here's the difference in the fees between filing things paper-wise as well versus filing it electronic-wise. Now, currently, an application per class is $750. They are proposing raising it up $100 to $850 if you're filing it through paper. Did you hear me? $750 to $850 for paper. And if you're filing it electronically, currently yourself, now this is without an attorney, this is just you going on the USPTO.gov website, filing your own trademark, all right? Currently, the TEAS plus, historically it was $373. Currently it's $250. That's where a lot of us file at, $250. We try to take the cheaper option. Let's just keep it real, right? Well, they're proposing to get rid of the $250 and raising it up to $350 per class. That's another $100 increase. So think about that. That's a 40% increase. So right now, currently, until these things become law and go into effect, you can still file your trademark application, the lower tier, at $250. If this proposal goes into effect, the basis now will be $350. Now, let's think about this. Many of you are not going to be trying to file your trademarks yourself. All right, let's just keep it 100. You're going to try to reach out to a trademark attorney. Where do you think that extra $100 is going to come from? Do you think that attorney, whatever their rates are currently, do you really think they're going to bite the bullet on the extra $100 that the USPTO is requiring if these things go into effect? So if you're struggling now to afford in your business to file your trademark, it's going to get even tighter if these things go into effect. So I want you to be mindful of that. So you continue to drag your feet, you're going to run out of time. All right. So that's part one that's going to kind of get you. So let's keep going. Now, this premium application that they're proposing to implement versus the two applications, right? They're proposed discontinuing the TEAS standard application filing fee and fees for failing to meet the TEAS plus requirements per class. They propose to establish new fees for filing a premium application when complete information is not provided or when custom identifications of goods and services are used. So this is for those of you that like to go and do it yourself versus using the ID manual. Right now, this right here where it says current fees, this is currently what's being charged for the things over here. As you can see here, currently you're paying $100 if you fail to meet the requirements of the application or if you file it during paper-wise, right? Like if you're mailing it in. They want to, right now you're paying $100 for both of those. They want to discontinue that, excuse me. I've been talking so much. If you look down here, the application for TEAS standard has been $350. That was the $350 application I mentioned earlier. They're saying we're going to get rid of that. Because obviously, like I just told you, they want to discontinue this too. However, if you look here, currently there is no charge for fee for insufficient information per class. So let's say you made a mistake or something, they're not charging you to make those corrections. Well, guess what? If this proposed fee goes into effect, you will have to pay $100. So mistakes are costly on your application. Same thing here. If you want to go and not use what's in the ID manual, they're going to charge you $200. Before, they didn't charge you that. Now they're going to charge you $200. So if you're a person and you're looking through the ID manual and you're trying to figure out what you provide in your business and what you want to trademark according to the manual, based on whichever class you choose or fall into, if you do something and you say, look, I want to add something that's not there because I don't see what I'm looking for, so I'm going to add my own thing, be prepared to pay an extra $200 on top of your application fee. So that's $350 plus another $200. So you want to go freeform it. They're not playing, y'all. These fees are not playing. So for one application, think about it, for one application, right? That's $350 under the new proposed fees. $350 for one application for one class. Let's say you got a clothing brand. All right, one class, $350. Now, let's say you're looking through the manual and you say, well, I don't really see everything I want to add in here. I want to add my own stuff. Okay, $200 more. $550. One trademark class, just one. $550. Currently, $250 and $350. You go up to $550. I'm just saying. Let's do the math. All right. So let's move on. Y'all realize, I don't know if they've been talking to Meta. I don't know if they've been talking to the people over at Twitter. I don't know what X, whatever you want to call them now. But as you can see in this slide, they're also implementing character limits. What is going on with everybody? Are they trying to say we talk too much? We typing too much? Because now the USPTO is proposing to hop on this train too. They are proposing to put a cap on what you can put on your trademark application. Hello, DJ Run. Hello, Liz B. Thank y'all for being here. They're putting a cap on what you can trademark in your application. Let's look at this. They're proposing setting a 1,000 character per class limit for free-form descriptions of goods and services. So if you're the person that says, look, I'll forget it. I'll pay the extra $200. I'm going to go ahead and freeform mine. You got some extra fees to keep adding on to what you're already paying. Okay. They're saying, proposing a fee for each additional block of 1,000 characters used in whole or in part if the ID contains characters in excess of that limit. So let's try to figure this out. What they're saying is for each additional 1,000 characters in excess of 1,000 per class, if you're filing it through paper, if you're sending it in, right now you don't pay for that. Right now, you can file your trademark as long as you want to. You can go through the entire ID manual for whatever class you're doing, and you can put everything on there that applies to you. So if you got 5,000, 10,000, 15,000 words, characters, they're not charging you for that. Well, now, this proposal, I guess I should say, they are saying that for each additional 1,000 characters, if you send it in through paper, that's an additional $200. For each additional 1,000 characters in excess of 1,000 per class, that's $200 electronically. So think about, because I had to go back and look at my own trademarks, and I was like, man, let me tell y'all, I didn't go tell you how much y'all would have paid for mine if I would have fell under these new proposed laws here. Child, I have a lot of words in mine. It's way over 1,000. So, characters rather. So I'm like, wow. And believe it or not, when the attorneys that were presenting before the board, when all of this was taking place, when they gave the public a chance to voice their opinions, this was one of the main things everyone was saying. This character limit is ridiculous. So 755, you said a mouthful. That's what it seems like. They are sick and tired of all these applications coming in erroneously. They are sick and tired of people just throwing stuff at the wall and seeing what will stick. They are tired of reading. They are tired of researching. They are tired of playing with all these people that's just willy-nilly throwing these applications together to include attorneys. And they're saying, okay, y'all want to play? You're going to pay. So, yeah, it's getting real with the USPTO.gov. And that's why I keep telling people, stop procrastinating on your brand, because come next year, because right now, here's the proposal. Everything I'm showing you all, they're proposing to have this implemented by the close of 2024, the beginning of 2025. In 2024, and I will show you later on the breakdown of what's going to happen in 2024. They're going to give the public they're going to have another hearing. They're going to give some of the people of the public a chance to voice your opinion. I guess they're going to have some type of vote or something. They're going to present it to Congress or whoever, and then they'll decide what the final thing is going to be. Right now, everything I'm showing you, as you can see, is their proposal. This is their packet. This is what they're going to be sending forth. This is what they have come up with as it pertains to trademark and patents. Now, this is just the trademark part. The patents is a whole nother thing, but this is just the trademark portion of what's being proposed. I want to make sure I make that clear. Now, my disclaimer, I'm not an attorney. I'm not a trademark attorney. I didn't go to school for law. I am a MBA graduate though, and I can read and write and comprehend, okay? And I can do arithmetic. Okay, so no, I do not have the JD behind my name. I do have MBA behind my name, all right? But this is not legal advice. This is just me sharing useful information with the people that want to know it. Because I don't want some of y'all to be blindsided when you do decide to file your trademark and you wait until 2025 and you get hit with all these fees that currently are not there at this level, all right? Luckily, in this slideshow, it's showing you what's current and what's proposed. So you can see, okay, let me start adding stuff up. I know I want to file my trademark. I know I want to file in this many classes. How much is this going to cost me now versus how much it's going to cost me later? Okay. I want to make sure I make that clear. So let's keep going. Character limits. Wow. All right. This talks about the Madrid applications and all of that stuff, how that's going to be changing. A lot of the things you can see here are free, right? Not applicable. There's no fee, but they're going to be proposing these fees onto these types of things here. All right. We're still moving. For those of you that's saying, look, I have this name, I have this brand, I have this slogan, I have this logo that I would love to trademark. I'm not using it yet, but I intend to use it within the next 3 to 6 months. I do plan on using this. What do I do? In that case, you file what is known an intent to use application. All right. That means, look, I plan on trademarking this, but I'm not using it in commerce right now. But before somebody takes it from me, I want to go and put that application in with the USPTO saying I do plan on putting this in, in use. That's your intent to use form. There's going to be changes to that as well. All right. This kind of goes through what all that means and what it all entails. I'm not going to get into that here for the sake of time, but you can look here. It tells you why. It tells you the reason for the adjustment and all of that stuff. So we're going to keep moving on. You want to file an intent to use. You want to do it. AAU per class paper. You already know what that means by now. Currently it's $200. It's going up to $300. That's a $100 change increase. 50% increase, right? If you want to do it electronically, currently it's $100. They want to raise it up by another $100, making it $200. All right. If you want to do a SOU, I'm not going to get into that here. Currently it's $200. It goes up to $250. It's a $50 increase for paper. Same thing for if you're doing it electronically. Currently it's $100. They want to raise it up by $50, making it $150. As you can see, all of these things are going up. And I'm not talking about a little chunk change for some people. It's going up. Okay. This may be the cheapest increase you're going to see is the $50. I'm just here to tell you. Oh, thanks, Tay. All right. So let's keep moving. Because here's a funny thing. Let me put me on the screen for a minute. Bring myself over here. Okay, let me just keep it real. Let me give y'all eyes a break from the slides. Y'all know slides can be boring sometimes. Listen to me. I have searched and searched on YouTube and Instagram, which is where a lot of trademark or intellectual property attorneys seem to be roaming, right? I have yet to see but one to even really announce these changes. And he didn't really go into, the full-fledgedness of these changes. And probably the only reason why he talked about it is because he was one of the attorneys that went to the actual USPTO and gave his view on these changes. He's the only one I have seen, but all these other ones that's all over IG, all over Facebook, all over YouTube, none of them have gone into this much detail. Not even the guy I just mentioned, not even him, as I am showing you all today. I don't know why, but they haven't. They have mentioned, oh yeah, the USPTO is going to be doing a fee increase. That was it. I'm giving you guys actual information from directly the USPTO, directly from the USPTO. I'm showing you their slides because I don't want y'all to think, oh, Ten's making this up. The Educated Natural just making this up, blah, blah, blah. We don't believe her, blah, 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 blah. She's not even a lawyer. You don't have to be a lawyer to read stuff and comprehend. I'm showing you what they are proposing. Now, for those of you that are going to become members of the channel, those of you that want to join up here with me, I have found the actual link to the videos of the whole presentation as well. So if you want to just see it and see who was there and who these people that was talking and who are these people that's making all these decisions, there's a public video for that as well. Nobody's showing that though. But I wanted to make sure that I keep you guys informed. Because when you do decide to file your trademark and you go with an attorney and that attorney says, well, this is my fee now, or you notice all these attorneys' fees just increasing, you will understand why. They're literally placing everyone, and I'm talking about from people like you and I that's filing our own trademarks to those that are using attorneys. Everyone's going to feel this. So while you still have some time, I wanted to make sure that you guys are aware. These are some serious financial changes. And if you're already struggling in your business, but you still want to protect your intellectual property, this is not the time to keep procrastinating on that. These fees could possibly, like in my mind, I'm thinking, okay, this is how it's going to be. Because I don't see them going down on these fees. I would be completely shocked if they go down on any of these fees. If they are hurting now, if they are having to hire additional staff now to keep up with demand, I don't see them changing that. Like attorneys want to get paid, right? The staff that works there want to get paid. Their stakeholders want to make sure they're getting their revenue, and everything has to get an increase. So I don't see them lowering these things. So in my mind already, this is just how it's going to be. But like I said, they're going to do a whole thing next year, the beginning of next year. This when the finalization of everything starts to take place next year. So you may have the rest of this year to keep twiddling your thumbs and thinking about it. But come next year, if you don't meet the time frame when they say, boom, we're implementing this, you're going to be out of luck. Now, let me give you a warning. If you're going to be filing your trademark yourself, you're welcome, 755 Media. If you're going to be doing these things, your trademarks yourself, heed my warning. If you don't know what you're doing, and I mean really know what you're doing, do not send that application in, because they're going to kick it back for the smallest thing. It takes the USPTO currently a year plus to even get your application on the desk of one of those attorneys there. Right now, according to their website, they are currently working on applications from the end of September, I think around about the 21st, 22nd of September to like the 2nd or 6th of October. That's where they are right now. Y'all see what month we're in right now. That's how far back they are. Okay. So this is not going to be a quick process, but at least once you file it, your effective date is the day that you file it. So if it takes them a year, you're still being protected regardless. All right. But just know this is not a quick process with them. Hence why they're trying to increase these fees, because they are swamped right now. But that doesn't mean you can say, well, they're overburdened right now, so I'm just going to wait. Study long, study wrong, baby. You better get that application in and stop playing. Because if you don't do it, somebody else might beat you to it. Then by the time you do put it in there, you get denied because somebody else that has a similar name to yours, if they don't take your name themselves, will file it before you, and you will be out of luck. Heed my warning, business owners. If you want to sit up here and call yourself a boss, if you want to sit up here and put all these entrepreneur big time titles on yourself, real entrepreneurs don't play when it comes to their business and their brand. They take it quite seriously. And they make sure that whatever they're building it on, they own. And I've told you in a previous video, and I will reinstate it here. You don't truly own your name, your brand, your slogan, your logo, or anything else you're over there building until you get a federal trademark on it. You can sit up there and try to keep playing with good faith and all this other stuff if you want to. And you're going to lose every single time. Why do you think these companies that you wear on your back and on your feet protect? They have hundreds probably of trademarks. Why do you think they do that? Why do you think that there are several, matter of fact, 3 entrepreneurs that are here on YouTube, that's kind of found, have said they're in fights with companies such as Under Armour, Monster Energy Drink, and Nike, because they use those companies' intellectual property, either the intellectual property itself or something similar to what those companies do. If you're an entrepreneur and you're using the term entrepreneur in your name, stop. Because Entrepreneur, who owns Entrepreneur Magazine, they come after anybody that used the term entrepreneur. Monster comes after anybody that has monster in their name. Anywhere, they coming after you. So trust me, if you know you are treading on someone else's territory that's already trademarked, heed my words, they are not playing with y'all anymore. So if you're a t-shirt designer and you're making these shirts and you're using the intellectual property of someone else, you better make sure you're not violating their guidelines, or you will be next. And one guy has already said he spent $4,000 because right when he filed his trademark, right, Monster waited until he was almost through the monitoring part of the trademark the day before the publication ended. That's where they give the public a chance to look at the trademark and see if they got something to say. They waited until he was almost there, and they filed a grievance against him. And now he had to pay like $4,000 just to be able to plead his case. And still, they're like, you got to come up with some more than that. You got what's your defense? So now you got to defend it against a company you were treading on, all because of the word monster. Who knew? I didn't know that. But these companies are serious. But I'm going to get back into these fees. I just want to let y'all know that. Steady long, steady wrong. So you're either going to keep playing with your IP or you're going to take it serious. But you're going to keep messing around and these fees are going to hit you upside the head. So let's keep going. All right, so this is where we left off at. Let's keep going to the next slide. All right, so these are the intent to use filings. The proposed splitting the current structure for 6-month extensions for filing an SOU into two tiers. A fee for the first through third extension and an increased fee for the fourth and fifth extension. What this is when you file your intent to use application, they give you 3 months. Now, it used to be 6 months. Now they give you 3 months. They shortened that too. You have 3 months to use it. All right. So let's say you say, okay, well, I'm still at the 3-month mark. Right before the 3-month mark, you said, I'm still not using it yet. I need some more time. You can file what's called an extension. So they'll extend it for another 3 months. All right. Typically, you can do this up to 4 times, I think, 4 or 5 times. Well, here's your fee list for doing that. All right. Currently, for the first, second, and third request for a 6-month extension for paper, currently it's $225. They're saying they're going to leave it $225. Yay. This one, the same thing. For the first, second, and third, they're saying they're going to leave it at $125 if you do it electronically. Well, here, for the fourth and subsequent request, Jesus, come on, mouth, for another 6-month extension. So you didn't do it in the first one, you didn't do it in the second one, you didn't do it in the third one. Here we are at the fourth time. You're saying, I still haven't used it yet. Well, now you're going to have to dig deep. Because currently it's $225 if you need another extension. If you need a fourth extension, it's $225. They're proposing it to go up to $350. That's a $125 increase. So you keep dragging your feet. Hey, David. Hey, T-shirt chick. You keep dragging your feet saying, I'm going to wait. I haven't used it yet. But you got this application on file. They're still having to monitor this application on file. So guess what? By that fourth time, they said, why haven't you used this yet? You're going to have to dig deep, $350. And that's if you're doing it by paper. If you're doing it electronically, currently $125. They're going to push it up to $250. So when I tell you keep dragging your feet, you're going to pay. So that's what the intent to use. So trust me, it's in your best interest to do it within the first 3 extensions or you're going to have to pay. Okay, let's keep going. Actually, it's best to do it, but don't even have to file an extension. Just get it done. So another thing the USPTO is saying, the reason why they have to increase their fees is because of maintenance filings. So they're saying they need to offset their costs, rebalance their fee structure. All right. So it's maintaining all of these things, all of these applications. You got inflation hitting them. You got the needing to hire more attorneys. You got all these things. You got improper filings going on. You got fraud from other countries. And sometimes here in the United States, all these fraud things that's going on that cost money to help track and maintain those things. That's maintenance. And it's like, it's getting tough for them. So according to this slide, this is one of the things that they're saying the reason why they have to put these fees up. So you can read through that on your own leisure. We'll keep going. So here we look at the maintenance filings, all right? So for registration renewal applications, these are those of us that already have trademarks in the system. You already have it approved, but now you've come up on those years later where you have to renew. Because in order to keep your trademark active, every so many years, you have to renew it. Well, if you're doing it through paper, the current fee is $500. Then now it's going to go up to $550, a $50 increase. Told you I don't see no increase lower than 50. Here, if you're doing it electronically for a renewal, currently it's $300. They want to raise it up to $350, $50 increase. Renewal fee filed at the WIPO, that's what I call it, the World Intellectual Property Organization. Currently is $300. They're thinking about pushing that up to $350, another $50 increase. So just want to let y'all know that things are going up. Keep moving. Some more maintenance fees. Declarations of use. If you're doing a declaration for paper-wise, $325 currently, they want to push it up to $400, $75 increase. If you want to do it electronically, currently $225, going up to $300. Declaration per class here for 71. This is 8, declaration 8 here. This is 71. If you're doing it through paper, $325 is going up to $400. Paper. Electronically, it's currently $225. It will be going up to $300. So these are for sections 8 and 71, maintenance filings. So let's go back. Here are some more maintenance filings for declaration of incontestability. Wait, did I do the other one? Okay, let's see what you did. All right. So currently paper-wise, $300. It's going up to $350. Electronically, it's $200, going up to $250. Letters of protest and petitions. I don't know if this needs explaining, but I'll give you a brief synopsis. You want to put in a letter of protest if you notice somebody has filed a trademark and you think it would be detrimental to you. You want to protest it, basically. There's a lot of this going on. So what ends up happening is you send that letter into the director takes a look at it, goes through the whole little system they have set up there at the USPTO, and they're saying enough of that. According to a report I saw, letters of protest went up in the last year or two, and they went from like a few thousand to a lot of thousands, like maybe 1,000 to like 4,000 or 5,000. It was crazy. So they were like, enough of that. Enough of these letters, because they have to look at everything that goes into them. So they're like, enough of this. This is ridiculous. A lot of these didn't even make sense. They were just over it. And so they're like, okay, so y'all want to keep sending in these letters of protest? Well, guess what? We're going to tack a fee onto that too. Hey, Blue Lotus Vibes, thank you for being here. So here's what they're telling all these people that love to send in those letters of petitions against other people's trademarks. They're saying, all right, currently $50. So in order to send a letter into them, you got to pay $50 to get your letter of protest even looked at. Well, they're saying, well, guess what? $250 according to this proposal. So they're going from $50 to $250. That's a 400% increase. They want to make you think about it big time before you protest somebody else's trademark. Wow. That's a huge jump. That's so far from what I can see, that's the largest jump of any of them that I've seen. That's a $200 increase just for you to send in a letter of protest. One of the gentlemen that was at the meeting and the forum they had, I mentioned earlier, his whole thing is this. He has a whole Facebook group that deals with stuff like this. And he even talked about it. He was like, this is ridiculous. You're hurting the people that's actually monitoring the things that's out there. Like, for instance, the people that use Etsy. I'll give you an example. The people that use Etsy. There are a lot of people that were going to Etsy and Creative Fabric and places like that. And you see a lot of slogans, right? You'll see a lot of terms, or, moms that love dogs or something like that. You know what I'm saying? You'll see those things. Everybody's putting them on shirts and all this thing. Well, I ain't gonna say somebody, it's just somebody's. There are people that's going to the USPTO filing trademarks on these common terms. And there are people that saying, wait a hold up. You can't go file that as a trademark. So what they're doing is they're literally writing these letters of protest saying this isn't right. This is common. This is a common term. How can you allow these people to file these trademarks? That's what a lot of these letters of protest are coming from. Etsy, Creative Fabric, all these things we love to put on shirts. We love to put on caps and everything else. All these common terms, there are people filing trademarks on those terms. Just want to let y'all know that, t-shirt makers. So if you're an Etsy seller, if you are someone that's on Creative Fabrica, if you're doing videos here on social media and you're showing these common terms, you might want to head over to the USPTO.gov website and see if that term has been trademarked or has been filed for trademark. Because once it's approved, they're going to hit you upside the head with a cease and desist. You don't want that in your life. If they don't hit you with litigation paperwork first, you don't want that. So it will behoove you, if you make shirts or any other type of custom apparel or items, you need to make the USPTO your friend, because they are literally approving some applications that may have the terms you have slapped on a shirt that you're selling. Because you saw it on Etsy, you didn't think anything was wrong with it. Yeah, it could be. So just want to let you guys know that. So they're also proposing fees for the petitions to the director. If you want to reach the director directly, there are fees for that. Paper-wise, $350 currently. They're proposing it to be $500. So for the director of the USPTO to even look at anything you have to send to her, because it is a female currently, $500. Okay. And if you're doing it electronically, it's going from $250 to $400. So if you want to talk to her directly, you're going to have to pay. All right, moving on. So these are letters of protest and petitions to revive an application, encourages efficient prosecution of applications and post-registration maintenance filings, encourages processing efficiencies in the event of multiple abandonments. These are the fees for that. Paper-wise, $250, $350 they're proposing. Electronically, $150 currently, $250 is what they're proposing. All right. So this is when they get into the path forward. I don't want to go through all of that. That's way too long. So let me put me on the screen. I want to get down to a particular slide for you guys to see. Okay, this is what they're saying. They're saying now, this would be good for you guys to know. Come on, why is this taking so long? Get on the screen. Get on the screen. I don't know why this is not popping up. All right, let's try it again. This is bananas. Wow. I cannot believe this thing is not on the screen. All right. For some reason. Oops, too far. All right, let's see if we can try it again. Seriously. This isn't Melon anymore, but Talk Studio, Streamlabs, I'm going to need y'all to get it together. Anyway, I'll just read it to you what it says. These people be tripping. All right, here's what it says. Can't believe this. All right, it says, this proposal is not final. It is a starting point. We look forward to your comments and suggestions. Please directly associate comments, favorable or critical, with the specific proposal under consideration so we can appropriately consider them. We will consider and analyze all input before preparing a notice of proposed rulemaking. We look forward to a productive dialogue over the next few months. Thank you. Yes, EJ's daughter, thank you for being here. They are nickel and diamond everything and some, the whole process. So I wanted you guys to see what the dates are. Come on, work with me here. Come on, work with me here. All right, let me take it all the way down and see if I can get it on here. All right, let's try this. I don't know what they're doing, but I'm sure going to report this. All right, let's see. I want you guys to see these dates. I don't know. Streamlabs. Y'all about to lose me. Y'all messing up the flow of my show. I don't like it. Hey, PIA. I know I spoke to you earlier. All right. It's not me, y'all. I promise. And anybody that's been using Streamlabs lately, you know. It is not pulling this up, and I do not know why. Which is weird. Because y'all really need to see these dates. Let me try it again. But how's everyone doing? I hope everyone is doing well. All right, let's see. This one. Trying to get this going. Well, I don't know, y'all. Let's see. You gonna work now? Seriously. Come on, dude. I don't know what they're doing, but I know I'm upset about it because they are not showing this. That is so weird. I see it on the side, but it is not showing it on the screen. That is so weird. Nope, still not showing it. I don't know, y'all. I don't know what's going on, but it is not showing it at all. Way to go, Tay Weezy. Yeah, man, the watch hours or something else. I don't know, y'all. But anyway, get your pen and paper. I'll just tell you what the slide says because for some reason it is not showing up on here. And I'm looking at my phone and I don't see it on there either. So let's see. Let's see if we can try something else since that's not working. Oh, now it wants to work. Like, really? It's better late than never, huh? Wait. All right. Here are the dates that you need to be aware of, my fellow entrepreneurs and business owners. June 2023, which we have already passed, they had the hearing I was telling you about earlier. January through March of 2024, published notice of proposed rulemaking. They'll publish it out there, wherever they need to publish it at. Hey, Tim, thank you for being here. I got to pay a fee. You're probably right, 755B. They're like, you have given too much information. We are not showing it. Oh, you're probably right. So March through June of 2024, public comment period. This is when they'll have a little form somewhere on their website. They'll announce it somewhere. And you can actually put your information there and say, I would love to speak. You don't have to go. You can do it virtually because this is what the gentleman that I saw, he did. One person did it virtually. And if they select you, they'll give you a chance to speak and tell them your thoughts. So that happens in March and June, all right, of 2024. No later than October of 2024 is when they will publish their final ruling. This will based on everything that they have said, everything they have heard from us and everybody else. That's when they'll say, okay, here is the final ruling. And my guess would be everything I just showed you. It probably won't change nothing, but they may adjust a little bit. It'll be a prayer, but we'll see. But that's the time period when they're going to publish their final ruling. November 2024, anticipated effective date of fee changes. November 2024 could possibly be the date when they enforce these new proposed currently will be law then fee changes. So basically, if my guess is correct, if I'm comprehending this correctly, you have until now, until November time, actually probably October if you're smart, October 2024 to get your applications in at the current rates before everything changes. So I want to make sure y'all have these dates. This is what they are looking at to start implementing these changes. All right. So what are y'all thoughts? What are your thoughts? Now, if you don't plan on filing a trademark, this probably don't mean a single thing to you. You're like, I don't care, but you don't know what can happen between now and then for you and your business. You can do one TikTok and blow up. You can do one business deal. Let's talk about that. Many of you, especially those of you that are trying to do affiliate marketing, affiliate deals, become affiliates for other companies, you're trying to start a partnership or business deal with somebody else, a big time company, you're trying to be the face of a company, whatever. You're trying to get your face and your brand associated with a bigger company, right? You need to pay attention to me because your lack of knowledge could cost you. So listen to me, Linda, listen to me. All right. If you plan on doing any type of affiliate deal with any company, I don't care who it is. There's too many of them out there for me to name. And they ain't paying me, so I'm not going to say the names. But you know who you want to do a deal with. If this is in your plan, if you are gearing up to do that, you, my friend, need to hurry up and file your trademark. And here is why. There have been a lot of people doing deals with other companies, and other companies have been playing on people's lack of knowledge because they will get you all wrapped up into the amount of money you're going to be making from this deal, and your legal mind will leave you. They're hoping on that because while you're celebrating, oh, I have this deal with whomever, their lawyers are filing trademarks attached to whatever it is you're going by. And by the time you come down off your cloud nine of celebrating this deal, and you think, oh, I need to protect my IP because I don't want these people stealing from me, you're too late. They already have it. There are big time celebrities who have gotten hit with this. And they have told you, you've heard the stories, I'm sure, as to where they had this name. They linked up with this big time company. This company was selling their products and everything was going good until it wasn't. And what ended up happening is that company tried to go underhandedly behind their back, had already trademarked that name, that brand, that line, whatever it was, fired the person, kept the name because they owned it. And now that person is out there like, I can't even use my name, man. I don't own it. Somebody else does. The company owns it. They stole my name. And you can sit up here on social media and cry till you turn colors. Ownership belongs to somebody other than you because you didn't protect your IP before going into that deal. That's why I protect my IP. The Educated Natural is protected by me. So I can take the Educated Natural and I can go do big deals with other companies. But that name follows me because I own it. I own the trademark. So they can fire me, but the name follows me because I own it. They don't. So I'm telling you this because there are certain celebrities that have fallen into this. And I don't want you to be next. So if you're going by a name and you have a brand and whatever your brand and your name is, and a company says, hey, I want you to be an affiliate for my company. I want you to sell these boots, or I want you to sell this handbag. I want you to bottle my clothes or whatever. And you're thinking, oh, great. You need to make sure you own your IP. That way, if something goes wrong, contract changes, money gets a little funny, you own your IP. So if they fire you, or if you decide to leave, your name, your slogan, whatever your IP is, follows you and not them. Because there is nothing more sad than to build your brand and turn around and somebody else owns it. And that means you can no longer use it. Yes, EJ's daughter, you saw these rates. Get busy, because they certainly are. Yes, ma'am. Skeezers. I haven't heard that term in a long time. Yes. They are not playing. That's why they have the big time attorneys who know these things. They're like, yeah, come on in. Come on. We would love to work with you. Come on in. And you're like, oh, yay. Oh, look. And you get on YouTube and Instagram and TikTok, and you telling everybody, I work with such and such. I'm an affiliate for such and such. And you all happy. And such and such is like, yeah, we're happy too, because now we're going to own you. Aha! And now when they kick you out, you can't even go back on your YouTube channel, because your YouTube channel has that name. You can't go on Facebook, Instagram, or any other type of social media with that name, because guess what? They own it now, not you. I'm just saying, we're working too hard out here. Stop it, PIA. You don't need that. Money comes your way. Money comes your way. You got this, sis. You're way, way too talented. I'm not even worried about you. You're way too talented. Anything you touch turns to gold. Stop playing with us out here. But I'm telling y'all, it's been too many cases. You think all these people you see on TV and magazines and all these things, videos, you think, oh, I know they got their stuff together. You ever hear their horror stories? Because we have a tendency to get so wrapped up in the financial aspects of things. We don't think business minded. You got to put your business helmet on, and you really have to think bigger, deeper, because that's what they're thinking about. That business's goal is to have you make them as much money as possible, even if it means they have to snatch the rug from under you to do so. I'm just telling you. I've read too many stories and saw too many videos. And you know I'm not lying. Some of y'all have shoes on your feet right now, and the original creator of it don't even own it. Some of y'all have watched TV shows right now, and the original creator of that don't even own it. And in some cases, they've been fired and can't even use the name because the company bought them before they could. I'm just saying, don't be next. Don't say I didn't know. It's a bunch of y'all in here right now. I'm telling you, protect your IP, or someone else will take it from you. And you do not honestly own your brand if you do not have a federal trademark. I don't care how long you've been in business. So you don't own it. Oh, you don't understand Educated Natural. I started this. My name is on this. My blood, sweat, and tears is on this. My mama, my grandmama, my great-great-great-great-grandmama, and granddaddy, we started this. Do you have a trademark for it? Well, no, everybody knows it's us. Everybody but everyone else in all the other states in the United States. They don't care. They do not care how long your family has had it. If it's not trademarked, you do not own it. Anybody can come touch it. I'm just saying. You don't have to take my word for it. You can search the USPTO. You can find these slides yourself. They're there. You can search all throughout the internet. Everything I have shared with you is there. Problem with us is we don't want to read. We don't want to study until something goes wrong. And now you want the whole world to stop because you didn't do your due diligence to protect your intellectual property. But once that trademark is filed, if it's not you and it's something you created, there's really not much you can do. You can go to court and spend thousands upon thousands of dollars trying to fight it and get it back to yourself. But first to file, that's a strong thing. So I wanted to make sure I shared this information with you all. If you have any questions, please leave them and I'll be glad to answer them for you. Be quiet, Tay. You got to be careful before you lose circulation in your feet. But I just wanted to come on today. I know it has been a while. I missed you all. And I'm trying to get used to this setup. I have my own office now. It has a door. That's not the door. That's actually a closet. But it has a door over here. So I close the door, have my own room. It's pretty cool. It's pretty cool in here. So I wanted to see, and I hope the stream went okay. I hope everything went okay. And if you have any questions, guys, look, I invite you. I'm going to be launching my membership probably tomorrow, probably as early as tomorrow. I'm still working on finishing up a few emojis and all that kind of stuff. But the minimum, because of the level of information that I do provide over here, the minimum will be probably $5, $5.99, somewhere around there and up, because I do share a lot of important information with you guys, exclusives. I will also be doing another video probably tomorrow later on and telling you guys what you can expect from the memberships, because I think that's very important, because there's nothing worse than signing up for a membership and you get nothing. So I want to make sure you understand that what I'm going to be providing to you, and make sure it meets your requirements, because there's nothing like putting something out there and people's like, I don't want that. I don't know what she or he putting that out there for. I don't want that. I want to make sure I'm providing you with things that are useful to you, that can help you expand your business. Because I don't know about y'all, but I don't show up to anywhere and do anything, whether it's professionally or personally, with the intent to lose. So I want you to have that type of mindset. Whatever you're doing, if you're making t-shirts, you're designing that t-shirt to be the best t-shirt it can be. You're not just throwing some stuff out there because your name is attached to it. And I want to make sure whatever I provide here to you is on that level. And if it's not, people tell me. Don't have me walking outside with my slip showing or toilet paper on my shoe. Let me know. Yo, 10, can you do this? Now, how about this? I welcome those types of things. So I wanted to make sure I came today and gave you as much information as possible so that you can apply this to your own knowledge base, so that you will know by next year, according to what I just showed you, by November of next year, which is 2024, these rates could possibly go into full effect. But be aware that the beginning of next year, January through March, is when they're going to put that public notice out there. And they may change some of these things. They may go up, they may go down, they may shift some things. We don't know. We won't know. But all we know is right now, these are the things that they are proposing as far as the trademark side of the house. Now, the patents, that's a whole different thing. Their rates are going up too. But I wanted to make sure I showed you all trademarks, because that's mainly what I know a lot of business owners need to do, or wanting to do, or have questions about trademarks. At least that's what I get a lot of phone calls about and emails about. So I wanted to make sure I gave y'all the trademark side of the house of what they are proposing. Thank you so much, EJ's daughter. I try. And thank God I'm able to do. So I am. Oh, thank you. Welcome in, Drunken Chef BBQ. Thank you, PIA. I didn't even see him. Thank you. Thank you for being here. Thank you. But yeah, thank you all for being here. If y'all have any questions, ask away. Because I really want to know how many of you are serious about your brand. You're not just out here throwing spaghetti at the wall and see if it sticks. You are really trying to build something here. You're really trying to build a legacy for generations to come. You're trying to leave your mark in this earth, and you want to do that by completely protecting your intellectual property. You're not out here on Facebook and Instagram and YouTube and wherever else just messing around. You want people to take you serious. And let me tell you from personal experience, ever since I have trademarked my name, I got it on my shirt. But ever since I have trademarked my name, the level of respect in the business world is crazy. And so it's like, they're like, wow, is that real? I think that's probably the number one question I get. Is that all real? You just putting it out there. I'm like, nah, it's real. You want to see the paperwork? You want to see the certificate? Matter of fact, all you have to do is go to the USPTO.gov website and look up my name. You'll see it yourself. So, but I wanted to let you guys know, we got to stop playing small, for real. We have to start operating just like these big, huge multi-million-dollar companies. I don't care if you're a hundredaire, like you only got $100 there. I don't care about it. You have to actually see yourself in the future. You got to stop thinking small, thinking, oh, I don't want to do it, whatever. You never know. You could be literally one video away and your life changing forever. It has happened to so many people. You could be next. Why not get things in order now to get the attention of those big companies? Say, hey, look, I have my own trademark. Here's the things I do. Here's the services I provide, blah, blah, blah. You have a whole complete package. That instantly puts you a step ahead of the rest. That instantly increases your brand positioning, believe it or not. All of that stuff. But if you're out here, you're just willy-nilly it and you're not taking your business serious, they're not going to take you serious on your business. They're just going to try to use you till they use you up. So let me see. I got a question. Let me see if I can put this on the screen. Will this go on the screen? Well, I tell you, this thing is tripping today. What about companies that contact you regarding publication of trademark on their site? Make sure I understand your question. Can you break that down for me, Teresa? I want to make sure I understand that. Trademarks on their site. Give me an example. I want to make sure I answer this the correct way. Absolutely, EJ. I do too. I want to leave my mark too. We just got our logo brand registered recently after 2 years. Good job. Good job. Great job. Great job. Drunken Chef BBQ. That's the way to do it. Where are you at in the process? Have you just I can't talk, Jesus. Have you just registered it like this year? So you're like at the beginning stages, you still got a year to wait, or are you closer to the end? Let's see. I don't see. Oh, it's done. Nice. So how was the process for you, Drunken Chef? Did you use an attorney? Did you do it yourself? I would love to hear your story. Okay, let's see. Teresa says, list you so you can search on there. They say they will list you so you can search on their database. They contact you regarding publication trademark. So are you saying that you're using someone else's trademark on someone else's site? They will list you. Tay, if you don't get out of here, I'm trying to get to understand. You said they say they will list you so you can search on their database. So a company contacted you and said they will list you on their database? Yeah, please clarify that. You're trying to say a company contacted you? Hold on, come back here, thing. Stop moving. I received a letter. Yes, seems like a scam. Probably is. There are a lot of trademark scams going on right now, sadly enough. It could be, I don't know. It could be a real thing. It could be a scam. That's where your research and your gut feeling is going to kind of kick in on this thing. I'm trying to understand. You said they will list you so you can be searched on their database. So there's a company with a database. They reached out to you. Is it to put your company in their database? Or they want you to list your trademark in their database? Because the only database for trademarks is with the USPTO, and that's directly through their website. Now, you can monitor this through the USPTO's website. Everything there is public information. But if you filed a trademark and another company that's pretending to be the USPTO is saying this, is a scam. It's a scam. So I'm trying to make sure I get a clear understanding of what you're saying, because it seems like you're saying another company has reached out to you about getting your trademark or a trademark in their database. It's only one trademark database, and that's with the USPTO.gov. This is another reason why they're claiming, the USPTO is claiming their proposed fee increase is because of all the scams that's going on, and they're having to fight against that from other countries and other places. Excuse me. Okay, I did it. Okay, here's what Drunken Chef says. He says, I did it myself, went back and forth a few times with some issues. I procrastinated on it for a long while. Then I had like a month before they were going to deny permanently, and finally got it fixed. Nice. Is it your name? Is it Drunken Chef BBQ, or is it something else? Yes, as you can see, even making changes, they can probably charge you for that now. This stuff is getting crazy. There's a lot to it. Better explain verbally. Yes, I found my own. So yes, there is a lot to file a trademark. Most definitely. Most definitely. I'm checking my phone, make sure everything is still on. All right, we're still looking good. Oops, sorry about that. All right, still looking good. All right. Yes, my logo with my name on it. You bring up a good point. Let me go over this real quick. For those of you that wants to file your trademarks. Now, there's been some misinformation going on out there. I saw was it a TikTok or a reel from Instagram? Either way, I saw it. And there was this person that was telling people, oh, as long as you file your logo with your name is automatically protected, and your logo is automatically protected. Let me explain this. He was wrong the way he was saying it. Completely wrong. How you file your trademark, whatever you're telling them you're trying to trademark, the way you submit it. So if you submit logo and name, right, it's only protected like that. You can't separate the two, put a logo over here in 1 minute and your name over here and think it's protected. No, it's only protected when it's like this, however you submitted it. So if your logo has your name and your whatever your icon is like this, and that's how you send it in, that's the only way it's protected. It's not protected like this, separated. I want to make sure I let you guys know that, because people think, oh, I'm protected. No, you're only protected when it's like however you submitted it. So for instance, if I take my name and I only trademark it like just my name, no icon, just my name, that's how it's protected. Now, if I go later and I put it with, if I just trademark just my logo by itself, I don't have my logo on this shirt, I just realized that. If I have my logo just by itself, then my name is protected and my logo individually is protected. All right. Now, if I want to go back later and I want to file another application and I want to protect it like this, logo, the icon, and my name, that's another protection. So now I've protected it just my name, I've protected it just my logo, and I've protected it name and logo. So however you submit it, that's how it's protected. All right. So Drunken Chef BBQ says that he protected his logo with his name on it. So that means he must have protected it like this, or however it is made, right? However it's made. It's only protected like that. Now, if he goes and he puts whatever he trademarks, separates it, it's not protected that way. There's two different ways. There's two different applications. I have somebody that's going through that right now. They went through an attorney. The attorney submitted the specimen, which is the example, like I was explaining to y'all before in the previous video. They submitted the specimen a certain way. They claimed design elements in their trademark. This is another content creator. They were denied twice. The lawyer went back, tried to petition, tried to make another way. They still said no. Okay. However you submit it on the application the first time, it has to be the exact same way on your specimen. It can't be deviant. You can't say I'm claiming color or stylized element of however you're doing it, and then when they look at your specimen, it's a total different color. It looks different. They're gonna say no. And I can't believe her lawyer didn't pick up on that, but hey, that's her bill, not mine. So Teresa says, got you. Now I got you. She said, yes, I started getting letters after I started my application process with the USPTO. Scams. Scams. Yes, ma'am. Let me explain. This is one of the things the USPTO has been talking about. Listen up, everybody. As soon as you file your trademark, I don't know who's monitoring this. I don't know how they're doing it, but you're going to get all sorts of letters from all these other supposedly attorneys from all over the place. Are they real attorneys or not? I don't know. But here's one thing I do know. They are scamming. You only pay one time at the USPTO. These people are monitoring every new application that goes through the USPTO because they're trying to make money. And 9 times out of 10, they'll sit there and say, oh, pay us X amount of dollars and we'll make sure your stuff gets through, blah, 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 blah. It's a lie. It's a scam. The USPTO has talked about that. If you want, Teresa, you can send that letter into the USPTO for them to be aware of it. It could be somebody new. It could be somebody they're already familiar with. It's a scam. I got the same thing. Probably somebody else has filed trademarks in here. Probably got the same type of emails from people. That's what they do. It's all a scam. After you file your application, probably within a year later, the USPTO themselves will send you your next status. Before you do anything, go to your My USPTO, which I hope you set up one. If you file a trademark, you should always set up your own account at the USPTO. You log into there and you can see the actual status of your application. Don't be looking at all these emails. If there was an issue, the attorney that is working on your application will reach out to you, and you can see it in your file at the USPTO.gov. Don't be letting these people set you up. And they're not going to be asking you for no extra money like that. You talk directly with the attorney that you can see on your application that's working on your file. You talk directly to them. But these other people that's out here, especially if you just did it, they're scams. They're scams. You can monitor your trademark in the process directly in the system with the USPTO.gov. Yeah, they don't play about that color issue. Drunken Chef. Yeah. Let me see. EJ says, so if he used his logo and not his name, someone could steal it and trademark the logo only. So if he trademarked just his logo, like a lot of people do, just trademark their logo, and they trademark it separately, but sometimes they do it in pieces because of the price. They say, well, let me get my logo. I'm mainly using my logo. Let me just protect my logo. I don't want to protect my name right now, or vice versa. All right. So, excuse me, you asked about a logo. So if he trademarks, if he uses logo and not his name, all right, logo, someone could steal it and trademark the logo only. No, what can happen is if he's trademarked his logo and not his name is still vulnerable. Vice versa, trademark your name, not your logo is still vulnerable. You have to protect them both if it's important to you. Some people do them both at the same time, just separate applications. You file one application for your name, you file another application for your logo. I always tell people to file them on separate applications. That way, if something goes wrong with one of them, it's not going to impact the other one. Just keep on separate applications. At least get one of them through, right? So increase your chances. But yeah, whatever you don't protect, somebody can steal. Point blank, period. People out here stealing for real. People get mad at each other on YouTube. Y'all seen these spats and all this beef sector, whatever is going on. People get in fights. They go right over to the USPTO, file a trademark, and then try to charge that person to get it back. petty, but it's happening. And that's probably why these increased fees, because the USPTO is aware of this stuff is happening. So now it's like corporal punishment for everybody across the board. So this one, my business 3 ways. Okay, Barb, you have to trademark your business in 3 ways. That's possible. Everything you do falls into a different class, possibly. So let's say you do t-shirts, because I'm only going by your name. You said it's custom made. So let's say you do t-shirts, you do mugs. That's one class. T-shirts is one class. Let's say you do mugs. That's another class. Let's say you do what else? Furniture. That's another class. Let's say you have your own inks. That's another class. Let's say you have your own paper. That's another class. So you can see how this could add up. That's why Nike and all these other big time companies have so many, because it's 40. Let me think. Goodness, I think it's 43 or is it 45 classes? Let's see. Let me look at it real quick. Hear me typing. Oh, oops, wrong way. Yeah, I want to know how many, because I think it's 40. Yes, please answer the question. Why is this not coming up? Maybe I put it right. Thank you. Seriously. Don't you hate when stuff just don't come up when you're looking for it? Everything else just pops up. That is not what I'm looking for. Yeah, there's 45 trademark classes, 34 classes for goods, 11 classes for services. All right, 45 classes. Yo, those classes were a trip. Oh my God. Yes, ma'am. And you have to choose wisely, because there are a lot of people that went and filed their trademarks themselves, filed it in the wrong class. And I'm here to tell you, the USPTO does not issue refunds at all. And that's a lot of money just to be waving bye-bye to because of a clerical mistake. You may have a nice attorney that may be willing to say, okay, well, we'll change the class for you. And there have been cases of that. You know, it depends on your attorney. Not all attorneys are created equal. I've seen some that are grammar police. You miss a comma, you misspell a word, they giving you an office action. They telling you no, and you got to go back to the drug. It's a mess. So that's why I tell people, do it right the first time. And you shouldn't have any issues. If it's filed correctly, it lessens your chance of an office action. But you go out there and just think you know and put the wrong thing out there. There are content creators right here now on YouTube who just did it themselves and didn't know what they were doing and got the big zero in return. They don't even have a trademark anymore. Well, they never had one. Their application just went declined and is dead now because they didn't file it right. So you have to know what you're doing or be willing to go toe-to-toe with them in the process. Have you helped anyone file? Here's the thing. Legally, no one outside of a trademark attorney is to file trademarks. The last year, fourth quarter of last year, the USPTO came out and they announced and spoke out against that. They implemented these rules and laws and blah, blah, blah to stop people from helping other people file their trademarks. I don't know if you went through this, Drunken Chef or Teresa, but if you notice that when you file your trademarks now, you have to sign up for ID, and you have to verify your ID. And they attach that to the filing of the trademark. That's one way they have locked it down. So you can't help anyone. You give them pointers, you can give them information and stuff like that. Is what I do. I educate you on how to do it yourself, but I don't touch nothing. My name ain't on nothing because I ain't trying to get in trouble. Because whether you realize it or not, filing a trademark is a legal action. It is a high price to pay, but it is a legal action. All right. So you don't want to just take that responsibility and you don't know what you're doing, nor do you have the credentials to back it up. So that's why I always tell people that come to me for help to file their trademark. Like, I can teach you how to do it. I can, I can't do it legally. I can do it if I want to do it for myself, but legally, I'm not supposed to do any type of comprehensive search for anyone or things like that. I can point you in the direction of people that can help you do that. These are actual trademark attorneys. If you need a trademark attorney, I can point you in a few directions to go. But I'm here to tell you from personal experience that if you plan on using a trademark attorney, I have yet to see a trademark attorney under $1,000. The highest one I have seen so far has been $4,000 for one class. That has been the highest I've seen. I'm sure everybody's rates are going to go up. If these new proposals go into effect, it's going to get higher than that. But I have yet to see actually now anyone under $1,300. Now, yeah, this year a lot of people's rates went crazily. They just went up. But I haven't seen anyone under $1,300 for one class. So, yeah. Barb. Some people have to file multiple trademarks. And you kind of pace yourself. If you have the dough, hey, file them all at one time, get them all out the way. If you don't, file the one that's the most important to you first and kind of go from there. That's what I always tell people. If it's your logo, if that's the most important, way more important than your name, file it first. If your name, way more important than your logo, maybe you're still trying to figure out what your logo is going to be, file your name. So whichever one and whichever class is the most important to you, that's the direction that you file. Oh, I was asked if I could issue a warning to custom apparel creators. And this is from an attorney, okay? They wanted me to make sure that I tell my audience, for those of you that are looking at filing in class 25, which is for clothing, if you do not plan on truly launching a clothing brand like all the other big time clothing brands that we all know about there, stay away from clothing trademarks. That's what they wanted me to tell you guys. And they said the reason for this is because of one of the things that the USPTO did mention during their briefing, not the slides, but during the actual briefing, the video that I saw, is they're noticing there are a lot of people that are filing trademarks, let's say today. But when it's time to renew, they don't renew it because they're no longer doing it. And the trademarks go from I think the 6-year point and the 10-year part, something like around that point. They're no longer wanting to do that. So the USPTO is seeing that as a waste of time. So the attorney is saying that if you don't plan on building your clothing brand, like for real, like a real clothing brand, not just a shirt that you want to put your name on, no, but a real clothing brand, file your money elsewhere. Because if you don't plan on being in it for the long haul, you're wasting your time. So they wanted me to pass that out there to you all, because there are a lot of people that say, oh, I make shirts, I want to trademark my shirt line. And they were like, okay, do you plan on being in this? Are you plan on growing this thing like a big time clothing brand? If not, you're wasting your time. File in another class. Do your research, pick a class. But if you don't plan on really building a clothing brand, a shoe brand, a hat brand, or whatever, you're wasting your time. This is what she wanted me to pass on. So I said that I would. So, oh, you don't remember if you used ID? Okay. But I know my last trademark that I did last year, I had to do the whole identification thing, and it wasn't hard. It's just that, dude, you really had to send in your ID. You had to send a selfie in. It was just the inconvenience of me just going in there, filling out the application and getting it over with. I had to verify my identity. So everybody has to verify their identity, and your name that you plan on signing at the end. You're not really signing it, you type it in. It has to match your ID. So if you got married and you didn't change your name, but the name you've been using is, your let's say you didn't change your name, but on your driver's license or whatever ID, it has another name other than the name you're going by. Yeah, that's gonna cause an issue for you. Your names have to match. Okay. So I want to let you guys know that. So if your driver's license is different than what you're going by, you might want to get that fixed before you try to verify your ID. Okay, it's gonna cause you an issue. They're gonna be like, nope, you cannot pass go. You cannot collect $200. No, you got to get that fixed. So I want to make sure you guys knew that. Any more questions? Well, at 1:40, well, now we're in 46 minutes. I don't want to keep y'all too long. Any more questions? But I would encourage y'all, take your time while you have a few more months. Take your time, do your research, decide within yourself if your brand is important to you. How would you feel if someone takes it? How would you feel if you go on Instagram and someone's using your name and it's not you? How would you feel if somebody doing products and services using that name or that term or whatever it is you want to trademark and it's not you? How would that make you feel? And then you have to ask yourself, am I doing enough to protect my intellectual property? Maybe you have to forego that new pair of shoes to take that money, put it to the side and put it towards your trademark. Put it towards a course of somebody that can teach you, like me, how to do your trademark. Put it to the side, let it stack up in case you're ready to go and talk with an intellectual property attorney. But what you don't want to do is just keep spending, and you can't protect your intellectual property, because what you don't do, somebody else will. And I don't want to see anyone on here, whether I've met you on social media or I met you in person, I don't want to hear another story of a content creator saying someone has stolen whatever. It's happening a lot. And I don't want you to be next. So if you have any more questions, let me know. We will get to it. But yeah, Teresa, if you need to speak with me offline, that's fine. You go to my website. Anybody can go to my website that would like to talk to me one-on-one. I do have a free 15-minute consultation. You can go to my website, and my website is www.theeducatednatural.com. That is my website. You can go to the contact portion there, and that's where you will find me. And if you need a consultation, we need to talk about your trademark or business thing you're thinking about doing, that's your free consultation time. Just get on my schedule. We are back in business. We are back settled, and we are ready to work for you. So if you need me, don't be over there scratching your head, pulling your hair out by yourself. Several of you have reached out to me. We had a good time on the phone talking, and I was able to get you and in some cases your children on the right road to get to where you need it to be. And this is what God has put me here for, to help you and educate you in any way that I possibly can. If you say, Kim, I need an attorney and I need an attorney now, can you give me a recommendation? I certainly can. Just inbox me and I will holler back at you. If you're serious about your business, as I've said before, please, for your sake and your legacy's sake, stop delaying, stop procrastinating, and get those comprehensive searches done by an attorney so that you can see if right now, today, you are in the correct position to get your stuff trademarked. Some of you are launching podcasts, you're launching things on social media, and you're not protecting it. And what I'm noticing is some of your names, or should I say similar names to yours, are already being trademarked in some of the fields you are either currently working into or thinking about going into. Somebody else already has a similar, very similar name as yours, and you're going to miss out when you try to go speak with an attorney and find out whether or not you can file your trademark. You're waiting too late. And I'm telling you now, you don't want to receive a cease and desist letter, because once you started getting those, that means they know about you and they're going to try to shut you down as long as you're using that name. And you don't want to be next. I personally had to send out quite a few cease and desist letters myself. And I'm going to have to send out some more here, some more, because people think I'm playing. But I don't want you to be next. So protect your intellectual property, in the words of Malcolm X, by any means necessary. All right. Okay, EJ got some to tell us. You're welcome, PIA, anytime. Is that site in your about section? My website? It should be. Story time. This is the first note of podcast today. What did you do? Look at the first erase in the name. It came out as a. Ooh. Seriously, EJ? Wow. Whoa. So yeah, you need to look, everybody, please lock down your names. I'm telling you, there is nothing more embarrassing than to go look up a fellow content creator's information, or maybe somebody you have seen in a video or something, and you go and you try to find them on other places, right? And it comes up with something like that. Wow. That's why I always tell my clients, and I always tell you all here, that make sure every so often you go and make sure that you are still Googleicious, meaning that when you look up your name, when you look up your product or whatever you've attached to yourself, whatever brand you're building, make sure you're the person that shows up. Because some of you are not Googleicious. Shucks, some of y'all aren't even YouTube-licious. I'm trying to look up names and handles, and it's not popping up. And I'm like, now I know this person's name. I see them all the time. Why, when I put in their name, it's not popping up? Somebody else is popping up. That's the wrong answer. That's the wrong answer. So please, if you don't do anything else today, check your stuff. Check and make sure you're showing up in Google. Please, for the sake of you, make sure you're showing up in Google. Make sure your channel is showing up in YouTube. Type your channel name, like for instance, EJ's daughter. She should be able to go to Google right now, type in EJ's daughter, and she should pop up. If she types in EJ's daughter, don't put it by video, just put it in the search bar, just like that. If she don't see herself, that is a red flag. She has to figure out how to get Google to pick her up. Okay? So please, 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 make sure that you are Googleicious. If you don't do anything else today, make sure you are Googleicious and people can find you on Google. And make sure if you're a content creator here on YouTube, make sure people can find you on YouTube. Please, y'all, please, for the sake of me, please listen to me. Those of you that's got 15,000 names, my Lord, please narrow that list down. Because if somebody finds you here on YouTube under one name and they say, you know what, I really like this person, I want to follow them on all social media platforms. If they go over to IG and they type in that same name, please don't be over there having a different name. And then if they try to find you on this new thing called Threads, please don't have another name. Please. Listen, you don't want to leave your audience confused, okay? You don't want to leave money on the table because of confusion. Let that be the least thing you have to worry about, because all across the board, you got the same name. Please fix that. I met one person this week. They gave me 4 different names for 4 different platforms. That's ridiculous. Oh, yeah, you can find me on YouTube under this name. You can find me on Facebook under this name. You can find me on TikTok under this name. You can find me on... I was like, dude, really? So please, do yourself a favor. Keep it simple. Keep it simple. Get one name. Put it across the board. All these different names, because you do 15,000 different things, is ridiculous. Pick a name. Goodness. That's why people say, how can I find you? I'm like, it's my name, The Educated Natural. Now, I do have somebody that's trying to do like this and call themselves this. But we're going to talk about that because we're about to handle that. I'm sick of them. We're about to handle that. But look for this. This is me. This has always been me. People trying to be slick. This has always been me. And you will always see my face, okay? Please, you don't have to go and look for all these other terms. It's me across the board. And there are some places I'm not at, but I'm here. I'm on YouTube. I'm on Facebook. I'm on Instagram. At least them 3. And I'm on Twitter. At least them 3, okay? Because that lady had me over here like, ma'am, why do we have all these different names and all these different platforms? Could you not make up your mind? Like, I know you missing money. Please, y'all. So 2 tasks today. Here's your 2 homework assignments, okay? Number 1, make sure you're Googleicious. Make sure when you go into any social media platform and you type in your handle, you're the one that pops up. Number 2, pick one handle. Pick one handle across the board if possible. Pick one handle across the board and promote that thing and promote that thing. Stop having all these different handles. It's confusion and it's time consuming, and time is money. And I just don't have time to be wasting my money trying to find out where you at, where you be. Okay. Stop confusing your audience. Make it simple. Say one name and that's all they have to go for. All right. That's all they have to search for, and they will find you. That's it, y'all. That's all I have for y'all today. I don't see any more questions. I thank you guys. There you go, Drunken Chef. Be Google-licious. I learned about that about 11 years ago. Be Google-licious. Google gonna pick you up if you make it simple for them to pick you up. You make it complicated, somebody else gonna slide in there, and it's not gonna be you. So continue, content creators, continue to put out great content, continue to do what you do, continue to promote your products and services, continue to connect, collaborate with each other. If you see somebody in the chat you're not familiar with, please go to their channels, go to their social media, check them out. If you like them, become a part of their family over there. You know how to do that. When we seeing that, y'all know what to do. If you want to see somebody's videos, you want to see them in your algorithm, you know exactly what to do. Okay, become a part of their family. Make sure you're following them and doing everything you need to do to make sure you don't lose that connection. All right, because I want you to come back to him. Who was that person that you was talking to in your video? I forgot. Write it down. If you can't do it now, write it down on a piece of paper. Type it in your phone and your notes. Don't miss these great content creators that are here in the chat. There's some very smart people in here, very skilled people in here. And they are bad to the bone in a good way, okay? So if you need something made, if you need a word from above, if you need IP protection, education, you need to know how to do something in business, look in the chat and find your people. Hey, Trish, thank you for being here. Hey, she is Sunshine. Hey, she is Sunshine. Good gracious, taught me to go. I can't even talk no more. But listen, if there's somebody here you're not familiar with, familiarize yourself with them. There's way too many content creators here for us not to all be growing and have monetized channels and all that great stuff. There's way too many skillful minds here for everybody's IP to not be protected. I'm telling you, like I said before, if you don't protect it now, you're going to wish you did next year. Okay. So if you missed any part of this video, rewind it back. We love replay viewers. And if you are a replay viewer and you make it to this point, thank you. Love you much. And may God continue to bless you for coming back and watching the last 2 hours. Okay. So thank you. Thank you. Thank you. Thank you all for rocking with me. Thank you, 755 Media. Yes. Everybody have a super great day. Yes. Hi, Ebony. Thank you. Hey, girl. Look, she came on her second channel. That's what I'm talking about. Hey, Tuck. I know who you are. Thank you for being here. Listen, you missed anything in this video, like I said, go back, watch the replay, leave me a comment. If you have questions, if you don't understand something, if you need something broken down to you, leave me a comment and I will do my best to make sure I do a video to make sure I answer your question. If I don't do a video, I'll leave it under your comment. How about that? I'll leave an answer for you. Okay. So until the next time, God allows us to come together like this and allows me to educate you on whatever topic he tells me to talk to you about. Like I always say, if you need to reach out to me, go to my website at www.theeducatednatural.com. It's right there on your screen and it's on my shirt. Hello. All right. You can always check me out there. If you need help with anything, you can reach out to me there. If you want a 15-minute free consultation, you can reach out to me there. If you would like to be a future guest on my podcast, you can reach out to me there as well. Yes, we are bringing it back because we have a lot to talk about, y'all. So we are bringing that back as well. We are safe and sound in our new location. Thank each and every one of you for your prayers. Thank you. We made it over. Thank you, Lord. So until the very next time, and until I see you guys here on these YouTube streets, boulevards, and street corners, like I always say, be blessed. Continue to be a blessing to others. And until the next time, enjoy your journey every second you get. Much love to each and every one of you.